So first we will talk about the Ninth Circuit and the Federal District Court denied me standing to challenge the two international treaties, the conventions. Because those international treaties are enforced domestically by the DEA, and because I am subject to that enforcement, then I should have a right to challenge those treaties. We all do. We have a right to challenge laws that affect us. And the lower court said that I did not. So this first part is about that. The Ninth Circuit denied me standing to challenge the conventions by creating a new rule that treaties must be self-executing to be judicially enforceable in our domestic courts. The Ninth Circuit's new rule directly conflicts with Supreme Court precedent, which provides that treaties become domestic law and challengeable in our domestic courts when Congress enacts implementing statutes. Each convention challenged was implemented by Congress through separate amendments to the CSA. The 1970 amendment was specifically designed in part to meet the United States obligations under the 1961 Single Convention. In 1978, Congress further amended the CSA to implement the 1971 Convention on Psychotropic Substances and the Schedule of Drugs thereunder. Moreover, as alleged, both the CSA and its related regulations set forth unique scheduling procedures for substances controlled under the conventions. Further supporting its denial of standing, the Ninth Circuit made a finding of fact in direct opposition to what I alleged. This directly conflicts with Twombly, which requires the court to accept as true all the factual allegations contained in the complaint. Specifically, the Ninth Circuit found that my injury would not be redressable because the conventions do not impose criminal penalties. This finding is untrue and contrary to my factual allegations for two reasons. First, I alleged in my complaint that respondents enforce criminal penalties for substances controlled under the conventions, and I am subject to that enforcement. As provided above, respondents enforce the criminal provisions of the CSA in the same manner, regardless of whether the substance was scheduled by the UN pursuant to the conventions or by respondents. In fact, many of the millions of arrests in the U.S. for simple possession over the past 55 years have been for substances scheduled by the UN pursuant to the conventions. Second, I allege a separate set of facts for my constitutional challenges to the conventions. Thus, should the CSA be found unconstitutional, that would not automatically extend to the conventions or Congress's implementation thereof, and could thereby leave my injury unredressed. By creating a new rule for treaty challenges and making a finding of fact contrary to what I alleged, the Ninth Circuit's ruling effectively made this significant piece of international criminal legislation untouchable and blocked me from challenging domestic law pursuant to which I am subject to criminal enforcement.